record. If you want to talk, please go outside.
Judge,
Hold on. So we're on the record. It cause number 253-4377, 2505-146. I think that's all we have.
A defendant locked up on felony charges, a protective order violated, and over 300 phone calls made from behind bars to the one person he's forbidden from contacting. But here's the twist. His high-powered defense attorney claims none of it is technically illegal. Welcome to one of the most heated courtroom battles over jail calls you'll ever witness.
I think that's all we have here, right?
Yes.
Yes. Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, E-A-D-Y, for Mr. Wiggins.
Nathaniel Munier spelled M-U-N-I-E-R, also for the defense.
So hold on, before you get into anything, State, you wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had at least 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So, Judge, I'm going to preface this conversation with, Miss Eady texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect, because it's been long enough that the protective order...
There's a court order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in...
Now, this is where things get legally fascinating. Defense attorney Daniel Munier just dropped what I call the felony bond loophole argument. Here's what he's saying. Yes, there was a protective order. Yes, the judge ordered no contact. But here's the catch. Wiggins isn't out on bond. He's in custody. And according to Munier, those no contact conditions were attached to bond terms, not general custody terms. So technically, if he's not on bond, did he actually violate anything enforceable? This is the kind of legal jujitsu that makes courtroom drama so unpredictable. The prosecutor is sitting there with evidence of nearly 300 calls since March 24th alone, 28 just yesterday. And the defense is essentially saying, show me the law that was broken. But Judge Fleischer isn't buying it. He's got one tool in his toolbox to stop this: administrative segregation, or the seg. That means Wiggins gets cut off from all phone privileges, not just calls to the victim. No calls to family. No calls to his other attorneys on the felony case. Total communication lockdown. And that's where this legal chess match gets even more intense. Stay with me.
He is in custody. He has not broken...
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Eady talking to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal...
The only way that we can revoke phone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies and
The
not being
only
able.
way, okay, I understand your plight,
Yes, Judge.
but there are other remedies for you to be able to communicate, letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. And in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail,
Did you catch what just happened?
M-U-N-I-E-R, also
Attorney
for the
Mounier
defense.
just threw down the
So
constitutional
hold on,
gauntlet.
before you get into
Fifth
anything,
Amendment, protection
stay.
against self-incrimination.
You wanted to bring
Sixth
something to the
Amendment,
court's
right to
attention.
counsel.
Yes,
Eighth
Judge.
Amendment,
So
cruel and unusual
we had,
punishment. 14th
received
Amendment,
a call
due
that
process.
Mr.
He's
Wiggins
arguing that
was
putting
in
Wiggins in
violation of
segregation doesn't just punish him
protective
for the
order
alleged
that was
calls
in
to
his
the victim.
VPO.
It
and that he was
obliterates
reaching
his
out to the
ability to
complaining
defend
witness in this
himself
case.
on serious felony charges.
We have checked the
And
jail
here's why
calls.
this matters.
Those jail calls
When you're
show
in the
that
seg,
since
every
March
single
24th,
conversation gets
which
recorded.
is, of course,
Even
after
attorney
the
visits. There's no
October,
privacy.
VPO.
No confidential
Since just March
strategy
24th, we have
sessions.
293
No
calls
ability
made
to
to
freely
the defendant's
communicate
phone number.
with your legal team on
Just yesterday,
cases
we
that
had
could
at least
put you
28
away for
calls
years.
to that number as well.
Judge Fleischer fires
So
back
in
with a
one
simple
day, you're saying
reality
he made
check.
how many calls?
You've called her over
yesterday, he
300 times.
attempted
What else am I supposed to do?
28 calls.
But Mounier
to,
has an answer for
the
that
complainant's
too.
phone.
Block the number. He even
So, Judge,
admits
I'm
he
going to
blocks
preface this
annoying
conversation
jail
with,
calls from
I was,
clients all the time.
Miss Edie texted me
It
about
takes
10 minutes
30
ago, so I
seconds
came
on
up on
a
short
cell
notice on
phone.
this. But
So why use a
my understanding is that
sledgehammer,
there's no longer a
segregation,
protective
when a
order in
scalpel
effect,
blocking
because
the
it's been
number
long
would
enough
work?
that the protective order.
The judge isn't convinced.
Or an order for
He's
him
been
not to
down
have any
this road
contact.
before with
Are those
Wiggins.
part of his bond
Last
conditions?
time they put him in the cell
My
for
client's
a
not on
month.
bond.
Wiggins begged to get out, promised he wouldn't do it
He's
again.
not supposed to have
And
any
now?
contact with her whatsoever.
300
I understand,
calls
Judge,
later.
but the way that
And
this
any
court and
jail
other courts
visits
in the
that
county
take
place in ag seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not prevent
Judge,
phone calls.
This would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms
It's
there.
not about me, Judge. It's about felony court is a serious issue, but that's the.
Why are
fifth
you
thing.
worried about felony court?
Because that's why he's in, Judge. Then
Well,
that's
that's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is, and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is.
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry, Judge, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not going to say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before, and I have admonished him before. Please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not going to do it, I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do, but now back in Act 7.
I'm going to sprinkle the word allegedly to the phone calls because this is the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I have them. I just have to get I have to do the forms or get them up with the forms. Yeah.
Okay, so let's set up a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
I'm trying to think of the last time that I got killed. It could be tomorrow, it'll be a few days. So, I don't know if we want to set it off next Monday or something like that. I think I should have it by then. This was just the point of that. Actually, not going to spend those places.
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they could.
Wiggins, I'm going to have you sign an affidavit today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of AGSEG. Do you understand?
No.
Don't contact the complaining witness. Don't use anyone else.
So here's how this played out. Judge Fleischer didn't immediately throw Wiggins into segregation, but he didn't let him off the hook either. He made Wiggins sign a sworn affidavit right there in court, a legally binding promise not to contact the complaining witness by any means. No direct calls, no third-party calls through mom or anyone else, no forwarded calls, nothing. And if he violates it, contempt of court, 6 months in jail, and a $500 fine for every single violation. The case is now set for a formal hearing on Monday, where the prosecutor will present the actual jail call records to prove the 300 calls really happened. Until then, Wiggins stays in general population, so he can still communicate with his felony attorneys. But here's the bigger question. Was the defense attorney right? Is segregation constitutional overkill when a simple number block could solve the problem? Or is Judge Fleischer justified in using the only tool he has to protect a victim from relentless contact? And what happens if those call records prove Wiggins made all those calls after being explicitly ordered not to? This case sits at the intersection of victims' rights, defendants' rights, and the limits of judicial power. It's messy. It's complicated, and it's exactly why cases like this matter. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules. I said real.
Yeah.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? Okay, so you want to set it for Monday? Okay. Let's just get it as soon as you can, get it to them. Have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that I truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
In the last time, he used someone else's SPIN number to make the phone calls.
And what's that?
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just before we start the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. You understand?
Sure.
Okay. Thank you, Judge.